Dear viewers, welcome back. In this 9th video, I'll bring you around the governance and enforcement framework created by the AI Act. Then, I'll briefly walk you through the sanctions that can be imposed. The regulation mentions a wide variety of enforcers and governance bodies for the AI Act. Some are created by the regulation, while others are existing authorities already tasked with enforcement duties under other EU laws. Some intervene at early stages regarding AI systems, for instance, before a risky AI system is placed on the market, whereas others are only active at later stages, so after marketing and deployment. Besides, the enforcement and governance framework includes both authorities at member states level and EU bodies and agencies. On top of that, some actors are meant to act as enforcers, strictly speaking, and others will rather provide guidance on the interpretation and the application of the regulation. Of course, they each have different powers and competencies. Let's take a closer look at them. At the European level, two main actors are created by the regulation. The first is the AI Office. The second is the AI Board. The Office, on the one hand, is a new branch of the European Commission, integrated in the DG Connect, so the Directorate General Communication Networks, Content and Technology. The rules determining its composition and functioning are therefore those of the Commission itself. The Board, on the other hand, is a completely new EU entity. It is composed of member states' representatives, one per state. Such representatives must have personal skills, but also powers within their home member states, so as to be able to fulfill the board's tasks. Practically speaking, one could compare the AI Board to the European Data Protection Board as established by the GDPR. On top of these two major actors, the AI Act creates an advisory forum composed of stakeholders from industry, civil society, and academia, as well as a panel of scientific experts skilled in AI and independent from industry. The office is granted with exclusive powers to enforce all provisions on general-purpose AI models. This includes, primarily, the designation of models as presenting a systemic risk, the evaluation of model providers' documentation to assess compliance with applicable requirements, and involvement in the drafting and adoption within industry of codes of practice for general-purpose models. Besides, the Office has to provide help in drawing up and adopting other type of codes of conducts alongside with member states. General codes focusing on the voluntary application of the material requirements imposed on high-risk systems for systems that present lower levels of risk. The Board, on his side, is more of a governance body. It is tasked with advising and assisting the Commission, including the Office, and the member states to achieve consistency and effectiveness in the application of the regulation. Among other goals, it is meant to help coordinate member states' national authorities, advise the Office on the implementation of the rules on general-purpose models, and, more broadly, provide recommendations and opinions on any matter related to the implementation of the AI Act. Turning to the panel of scientific experts, its objective is to provide support in the enforcement activities conducted under the AI Act in general, with a particular focus on helping the AI Office for its tasks regarding general-purpose models. Concretely, the panel will be involved in the drafting of codes of practice for general-purpose models, in triggering alerts of systemic risks for such models, etc. As regards the advisory forum, its raison d'être is to provide expertise and advice to both the Board and the Commission. At their request, it may prepare opinions or recommendations on matters relating to their respective tasks. Finally, and although it is not related to EU enforcement tasks strictly speaking, I wish to highlight that the Commission will draft guidelines on the implementation of the AI Act to give market operators practical information helping them to properly implement the regulation. The enforcement framework at national level is divided in two major categories of authorities, each comprising two subcategories. On the one hand, there are authorities tasked with enforcement for high-risk systems qualifying as such under Annex 3, so the use cases deemed to create high risks. On the other hand, a different group of authorities is required to enforce the AI Act for high-risk systems qualifying as such under Section A of Annex 1, which is a list of sector-specific EU laws. It includes the directives on machinery, safety of toys, radio equipment, etc., as well as the regulations on protective equipment, medical devices, and so on. Within the first category, so the use cases of Annex 3, the AI Act imposes the designation of, at least, one notifying authority, who designates third-party conformity assessment bodies, aka notified bodies, and one market surveillance authority for each member state. These two types of enforcers can be new authorities, specifically created to satisfy the requirements of the AI Act, or they can be existing entities. For instance, EU data protection authorities already made a common statement to ask being designated, each in their own member state, as market surveillance authorities for high-risk systems processing personal data. Within the second category, high-risk systems under Annex 1, Section A, existing authorities will be involved. Such authorities are those already tasked with third-party conformity assessments, so notified bodies, under the sector-specific EU laws listed in the Annex, and market surveillance under the same acts. This being said, let's take a step back. In Section A of Annex 1, there are 12 EU acts. If under each there is one notified body and one market surveillance authority per member state, knowing that the EU contains 27 member states, it means that there might be up to 2 times 12 times 27, so over 600 authorities in the EU tasked with enforcement duties under the AI Act for sector-specific EU laws. This is, very likely, why the board's missions include coordination between member states' national authorities. One final layer, at member states level, is that of the authorities protecting fundamental rights. Yet, they have lighter tasks and interventions regarding the enforcement of the text as such. I'll come back to it later. The nature of their respective tasks can be inferred from their names. In particular, notifying authorities are meant to designate conformity assessment bodies and monitor them. Notified bodies will evaluate the conformity of high-risk AI systems vis-à-vis the material requirements of the regulation and approve or not the marketing of such systems by their providers. Market surveillance authorities are tasked with post-market monitoring. It consists in watching over markets, ensuring operators take appropriate corrective actions where serious incidents occur, or taking themselves adequate measures where operators fail to do so, for instance, withdrawing or recalling systems when necessary. When incidents involving risky AIs take place, they also have to inform authorities protecting fundamental rights. Authorities protecting fundamental rights may investigate high-risk systems on their own initiative or next to a notification from market surveillance authorities to verify whether they respect or not fundamental rights. On top of all that, national competent authorities, so both notifying authorities and market surveillance authorities, may provide guidance and advice on the implementation of the regulation. The range of sanctions foreseen by the AI Act is very similar to that of the GDPR. It scales from warnings, so non-monetary measures, to high penalties. Of course, depending on the level at which the enforcers are active, member states or EU, different sets of rules will apply. At member states level, administrative fines will be imposed on offenders. They will range from an upper limit of maximum 35 million euros, or 7% of the offender's worldwide annual turnover, in the worst-case scenario, that is to say, a breach of the rules on prohibited AI practices, to a lower limit of maximum 7.5 million euros, or 1% of the offender's turnover, in the case of false or misleading information being provided to national enforcers. In between these two extremes, most breaches will be subject to fines with an upper limit of 15 million euros, or 3% of the offender's worldwide annual turnover. At the EU level, regular fines will be imposed on offenders, so providers of general-purpose models. The maximum amount that can be fined is 15 million euros, or 3% of the faulty provider's turnover. Thanks for watching, stay tuned.